Welcome to meeting number 34 of the House of Commons Standing Committee on Procedure and House Affairs. Pursuant to Standing Order 108, Sub 3, the committee is meeting to continue its study of Bill C-25, an act to amend the Canada Elections Act, and an act to change the names of certain electoral districts, 2026. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are in person in the room and have the option to appear remotely on Zoom. Before I continue it, I'd ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and for help protect the safety of everyone, including our interpreters. There's a QR code. Please watch the video. I'd like to remind witnesses that committee members may ask questions in either English or French. If you need interpretation, please take a moment now to prepare your earpiece and select the listening channel you need in advance in order to take full advantage of the time allotted for questions and answers. Just a few comments for the benefit of members. All comments should be addressed to the chair. If you're in the room or on Zoom, please raise your hand and we will do our best to call on you. I would like to welcome our witnesses for today's first panel. As individuals, Gerard Chippier is a lawyer, Yves Gamond, a lawyer and PhD student, and Peter Lowen, the Harold Tanner Dean of the College of Arts and Sciences, Cornell University. Welcome to everyone. You will each have 5 minutes to deliver opening remarks. We will start with Mr. Chippier. 5 minutes, please.
Thank you very much. Members of the committee, in my submissions, I plan to address 4 edits that I believe will improve Bill C-25. But before I address those edits, I would like to state that Bill C-25 will significantly improve the protection that Canadians have with respect to the electoral process and will increase the protection from hostile state actors and others outside Canada desiring to influence Canadian elections. So thank you for those proposals. I would also like to remind the committee of my previous recommendations that the nomination process should not be governed by the Canada Elections Act. So I continue to recommend that nomination processes be left entirely to the parties, and that is something that I continue to recommend because it is my view that in its current form, the Canada Elections Act continues to violate Section 3 of the Charter in the manner highlighted by Justice Epstein of the Ontario Supreme Court. In 1999, in the Galati and Ontario Liberal Party, Justice Epstein said this: "It is apparent from authorities that, contrary to the plaintiff's claim, the intervention of the government in the nomination process of political parties would constitute a breach of constitutional rights." I think he was right then, and I have seen no cases that would challenge that conclusion. Now to the 4 edits. First, I recommend the removal of certain unnecessary red tape. Second, the preservation of the neutrality of the administration of the Canada Elections Act. Third, the prevention of certain fraud and abuse. And fourth, the protection of freedom of expression. My first point is on the question of privacy. It is my view that we do not need amendments related to privacy. In my view, the cure is worse than the disease. The publication of voter names and addresses has never been a problem in the past. At least I'm not aware of any problems. No harm has come from that. And in any event, there are thousands of people across Canada who have these voter lists, and nothing has come from it. I recommend that you don't go there, but likely you will. So if you do, my recommendation is that at least delete your proposed Section 385(2)K and Section 387 of the Canada Elections Act because they are duplicative. There is no need to have a role for the Chief Electoral Officer if you already have it statutorily set forth. The statute sets forth in Section 446.6 the rules that will apply, but then says a political party must have a policy and that the chief electoral officer has a role in approving that policy. My view is there should be no role for the CEO. There should be no policy. Just follow the act if you're going to have rules related to privacy. And there's a Court of Appeal decision on that, Longley in Canada, 207 Ontario Court of Appeal, but I won't read that because of the limitations of time. Another very important change is with respect to neutrality. Right now, the Act allows the commissioner to proceed to investigate and require testimony under oath without judicial review. That is problematic because it gives the commissioner the opportunity to move forward without an independent third party saying, yes, there's enough evidence here to interfere with the right of the subject that typically is in place with respect to criminal law to remain silent. It just doesn't make sense to allow the chief electoral officer to have that, or the commissioner to have that kind of power. My view is the rules in section 510.01 that require judicial review should apply to any of the investigatory powers exercised by the commissioner. I have three great recommendations for the issue of the abuse of the ballot. And I know I'm probably over time.
10 seconds.
Okay, three. One is require 200 signatures instead of 100. Secondly, take out the limitation in 477.2 to the same electoral district. And third, my recommendation is in your ballot, have the parties listed first in alphabetical order, and of course, changing with each ballot. So you have the parties listed first and all individuals listed second. Therefore, you're able to allow individuals to make a wise choice if they choose to. And I'll stop there.
Thank you so much. You'll have plenty of opportunity to expand on that. We will now go to Ms. Gaumond, please. 5 minutes.
Thank you, Mr. Chair, and thanks to the committee for the invitation to contribute to your discussions on the Canada Elections Act. Mon nom est Eve Gaumont, je suis avocate et doctorante à la...
My name is Eve Gaumont. I am a lawyer and a doctoral student at the Faculty of Law of the University of Montreal. My research focuses in particular on the Canada Elections Act and the preservation of electoral integrity. I served as a guest expert at the Citizens Assembly on Democratic Expression as part of Election Quebec's work and during the Canada-Netherlands consultations on the Global Declaration on the Integrity of Online Information. I have also taught privacy law at Université Laval. Bill C-25 is a good bill. It is not perfect. In terms of privacy protection, it falls far short, and improvements could be made regarding the transparency of online political activities. But at a time when trust in democratic institutions is eroding, it is important to focus on one thing. Even though there is always room for improvement, the current legal framework is robust and resilient, and it has effectively protected the integrity of Canadian elections to date. My comments will focus on the two aspects of the bill that I believe warrant improvement: the privacy regime and the transparency mechanisms designed to ensure the integrity of online political activities. Given the time I have, I will briefly touch on each area for improvement, but I have submitted a list of written recommendations to the committee, and I will be happy to elaborate on them further during the question period. Regarding the issue of personal information protection and privacy, we must draw a line between what falls under the Canada Elections Act and what falls under privacy laws. These are two legal frameworks that serve different functions. The purpose of the Canada Elections Act is to establish the rules of the game to ensure the integrity and proper conduct of elections. It is entirely appropriate that it includes offences concerning certain problematic practices in a political context, such as selling personal information held by a party or disclosing personal information to cause harm, for example. Section 36, for example, is relevant. That said, the Canada Elections Act cannot be used to create a comprehensive and exclusive national privacy protection regime. The right to privacy is a complex and technical field that cannot be addressed in passing within a legislation dealing with other matters. It is therefore essential to repeal sections 446.2, 446.3, and 446.4 so that existing provincial privacy laws can apply to federal political parties, at the very least until a truly comprehensive national regime is established. The federal law should seize this opportunity to bring federal political parties under this regime. It is concerning that political parties are the only Canadian organizations not subject to the basic privacy rules, especially when we recall that the Cambridge Analytica scandal essentially revolved around the use of personal data for political influence. Now, regarding transparency. The elections legislation is largely based on the idea that transparency promotes integrity. This principle holds true in the real world. But to ensure that the activities in the virtual world meet equivalent transparency standards, 3 measures should be considered. First, adapting certain existing regulations to the reality of artificial intelligence. When a party uses automated calling systems, it must register with the CRTC and submit a list of the phone numbers contacted, along with a copy of the recorded message or script that was used. Parties that use chatbots to communicate with voters should, at a minimum, be required to provide the prompts used to program the chatbots, as well as a list of the voters who were contacted. Political parties should also be required to disclose when they share content that has been generated or significantly altered by an AI system. The second has to do with influencers who are playing an increasingly important role in the political sphere. Currently, they often fall outside the scope of traditional transparency rules. The addition of a specific regime to govern campaign expenditures offered in exchange for endorsements should be considered. Such a regime could include a requirement for influencers to label sponsored content and disclose any significant ties they have to a political entity, including benefits and incentives. The final change concerns digital platforms. Section 325.1 should be amended to require major platforms to play a greater role in promoting transparency in online political activities. This means the government should collaborate with researchers and platforms working on election integrity issues and to codify expanded transparency obligations. These obligations must ensure that researchers can access the data needed to study Canada's information ecosystem, regardless of the political affiliations of the people leading these platforms. Thank you.
Merci.
Thank you so much. Now turn to Mr. Lowen for 5 minutes, please.
Thank you very much to the committee for this invitation to appear. I understand the committee is considering questions related to electoral district naming, including proposals affecting a small number of constituencies with Indigenous names. I'm grateful for the opportunity to comment on this issue, and I hope I can be helpful to the committee in its consideration not only of these particular cases, but also broader questions surrounding the naming of ridings in Canada. I want to make 3 points in the time that I have. First, there are good reasons for including more Indigenous names in our constituencies. Second, the process for considering Indigenous matters during boundary redistribution could be revisited. Third, the process or the practice of naming constituencies could likewise be reconsidered. I've appeared before this committee several times, usually on the basis of my expertise as a scholar of elections, electoral systems, and democracy. I gather I'm here today as one of 3 commissioners who was responsible for redrawing Ontario's federal boundaries in the last process in 2022. I did take occasion to consult with the other 2 commissioners, Madam Justice Leach and Professor Bird, and they're largely in agreement with what I have to say here today. It was an honor and a privilege for all of us to take part in that work and to serve Canadian democracy in that way. As part of that process, my fellow commissioners and I believed it was important to better recognize Indigenous peoples and histories in constituency names. The substantive representation of Indigenous peoples is explicitly considered in redistribution law and jurisprudence. The naming of constituencies is much less systematically addressed. I'll return to that point below. My first point, though, is that there are good reasons to include more Indigenous names in our constituencies. The first is that Indigenous place names are already deeply embedded in Canadian political geography, even if we do not always stop to notice. Mississauga, Skeena, Nanaimo, Temiskaming, Etobicoke, even Brant. These names derive from Indigenous languages, Indigenous peoples, and Indigenous history. They are familiar to Canadians. They are understandable to their communities. And they remind us that our political geography did not begin with Confederation. The second reason is reconciliation itself. This asks us, at least in part, to share more fully in the history of the country. It asks us and asks Parliament to strive to make our institutions places where Indigenous history and representation are visible and able to thrive. Parliament is an institution for all the peoples of Canada. It becomes more fully Canadian when it incorporates more of the histories and traditions of this place, not out of guilt or shame, but out of a desire to better reflect the country we actually inhabit. Part of this process, I hope, is that Indigenous names and writings may encourage Canadians to learn more about the Indigenous past and present of the places where they live. I'll give you just one example. It's humbling for me to think about what may have gone through the mind of Etienne Brule as he traveled down the Humber River toward Lake Ontario, becoming likely the first European to see the Great Lakes. Shortly before reaching the lake, he likely would have encountered the area and the people around Taiayakon, a large and sophisticated Indigenous settlement near the river. Looking toward the lake, he would have seen a landscape very different from the one we know today. Long houses, cultivated land, black oak savanna, and burned grasslands where High Park now stands. This was a civilization long before it was Babby Point. We recognize and remember things by naming them. On the process, 2 points. First, the redistribution process is sequenced in a way that maps are drafted and ridings named before public consultations occur on particular recommendations. The sequencing could perhaps be revisited by Parliament and by future commissions, though it would be difficult to change in practice. It's hard to consult on particular riding names until an entire map has first been constructed, but perhaps a different process is possible. Second, members might consider whether Parliament should routinely alter names recommended by independent commissions after redistribution has concluded. You might also consider whether changing riding names is the first step to changing other features of ridings after the process has concluded. MPs should not, I contend, get to name their own ridings, which might be a fair characterization of what is happening here. I'd be happy to discuss that point further. And now a final observation. Ridings do not necessarily have to be named after places. Australia commonly names electoral districts after historical figures, and provincial ridings in Quebec, for example, often follow a similar practice. There's much to recommend that approach as well. I personally think there's value in the geographic naming of ridings because our electoral system remains, at least in part, a system of geographic representation. I hope these remarks have been helpful. I look forward to your questions. Thank you.
Thank you so much. We will go to Mr. Cooper for 6 minutes.
Thank you, Mr. Chair. Thank you to the witnesses. I'm going to ask some questions to Mr. Chip here regarding third-party financing. As you noted, the bill closes certain loopholes in the Canada Elections Act that have been exploited by foreign actors and certain registered third parties in terms of foreign actors and foreign interests being able to fund registered third parties for regulated activities. In that regard, the bill as a general rule requires registered third parties to set up a separate bank account for regulated activities with the stipulation that contributions to that bank account only come from individual Canadians. However, there is an exception where third parties can use their own funds for regulated activities if contributions constitute 10% or less of a third party's revenue in the year prior to the pre-election period. According to the Chief Electoral Officer, where this exception applies to a third party, the funds used by the third party would be treated as commingled, whatever the source. So that could mean contributions from a foreign source, hypothetically. Would you agree with this third-party exception in the bill, the 10% exception, loopholes that have enabled third parties to use foreign money for regulated activities are not closed and, in fact, remain wide open?
I would agree, and I would point out that it is completely inconsistent to provide in Section 349.914A to C that there is a $200 limit on the, or a $200 registration requirement. So anything over 200 must be registered there. Yet we could have 200 million come in if your organization was was spending $2 billion, and there are foundations that have that kind of money. There are organizations, corporate organizations, that have that kind of money. So it's illogical to have these two sections right after each other where you're creating something that a freight train could drive through.
Right. When I questioned the Chief Electoral Officer about this loophole, he rebutted by citing general provisions within the Canada Elections Act that prohibit the use of foreign funds by third parties, but these general prohibitions against using foreign funds have been readily exploited by foreign actors and certain registered third parties, correct?
But my point is that yes, foreign might be prohibited under another section, but the whole idea of third-party regulation that was upheld in Harper is the idea that everyone is going to be fairly governed. And in this case, certain organizations, because of the fact they have a lot of money, will not be treated the same as other political parties. In particular, will not be treated the same as members of parliament or political parties. They will have an advantage just by their size.
Okay, and I agree with that. Now, the Chief Electoral Officer has said that this exception is necessary due to charter considerations, including freedom of speech and freedom of expression. Does that make sense to you?
Well, okay, I'm going to give you my personal and then my professional opinion. Personally, I disagree with Harper. And so I would agree with the Chief Electoral Officer that we should have absolute freedom of expression. I don't like those kinds of limitations. But that's not the law, and I have to live with the law, and so does Parliament. And Harper and all of the cases following Harper make it clear that you may limit third parties, and you may require all donations to be identified. There is nothing that I am aware of in any precedent that would suggest that there are some individuals who get to make secret donations and don't have to disclose those because of the charter. That's just not the law.
Now, you have extensive experience as a constitutional lawyer, correct?
Yes.
And is it your interpretation, your view, that if this exception were removed, that it would be charter compliant?
Absolutely. There's nothing that the charter requires with respect to disclosure. This is just disclosure. It doesn't cause someone to remain silent. It just simply requires them to disclose the fact that they're spending money during an election.
Now, it seems to me that the best approach towards closing the very large loopholes that exist that have been readily exploited is to consistently apply what this bill attempts to do for what I believe the government thinks would be the vast majority of registered third parties, and that is simply to require all third parties, instead of all but those that apply where the exception would apply, to simply set up a bank account and solicit contributions from individual Canadians. Would you agree that that is the best approach?
Absolutely. Very administratively simple, straightforward, and consistent with the law that applies to everyone else.
15 seconds.
Okay. Thank you, Mr. Chair.
Thank you so much, Mr. Cooper. We'll now turn to Madame Brière for 6 minutes, please.
Thank you, Mr. Chair. I will ask my question in French. Maître Gaumont, bonjour.
Ms. Gaumont, welcome, and thank you to all the witnesses for being with us today. We are debating disinformation, deepfakes, content online. Many are concerned regarding the measures in C25 that they would perhaps limit comments that should be protected by freedom of expression. Do you believe that C25 is able to strike a balance between protecting the integrity of the election process and also the necessity to not criminalize comments that are legitimate? I think that C25 is good legislation. There is a measure on impersonations. I could find it. Paragraph B, I believe, has to do with recordings that are falsely representing what someone said. So this might be one element that is not precise enough. I'll try to find that element. But another thing is when we talk about the use of technology and deepfakes, we could perhaps talk about a sunset clause. So for now, we want disclosure. This is currently banned, but we could reopen the door to reinterpretation later if the use of AI becomes legitimate, generalized, and is no longer a problem. But I find that C25 does strike a good balance. Mr. Chipper?
That question too, and if you can include the 10% thing.
And I would agree with my colleague that there is, generally speaking, a good balance within the bill. I do agree that sunset laws are wonderful and that it would be a good idea to revisit it and require yourselves to revisit this very shortly, because the law, it's not just the law changing, it's technology that's changing daily, it seems. I would suggest that you do revisit one section, and that is the final section, which is section 482.01. There is a list of things that are prohibited, and one of the last ones, 482.01G, allows prosecution where someone comments on the results of an election. Now, the problem with that is that Part 20 of the Act allows you to challenge the results of an election. So I could see someone saying, I think the chief electoral officer lost a ballot box. Well, that sounds like you're challenging the results of the election. And if you had a debate over that was in a civil court and you decide was it or was it not lost, fine. But to put it into quasi-criminal territory where just because you have raised that question now in a prosecution, you would have to prove your bona fides. Your good faith would be on the table. And think about it. Once the election's over, how could your commentary be an impact on that election? It's already done. So to me, 482.01G goes further than necessary and therefore would not be a reasonable limit in a free and democratic society under Section 1 of the Charter.
Pour parler là, du finance.
And now regarding funding and that 10% limit regarding freedom of expression, can you respond to that?
The 10% limit, it's not a 10% limit, it's a 10% wide open, in my view, train track. If you are a big organization with a lot of money, 10% is way more than $200. So if I am your average citizen and I have $200 to spend as a third party, I have to register. But if I have millions of dollars and I want to spend $200, I don't have to. But the more important thing is where I got that $200. So basically, I can go around and get money from people who don't want their identity exposed through the registration process. I might myself say, as a libertarian, I don't think we should have that process, but we have it. And if we're going to have it, then I think it should apply to everyone. And just because you're rich, you shouldn't be able to get around the requirement of telling the world that you gave money, you gave a donation to participate in the political process.
There's 3 seconds left. Oh,
Thank you.
sorry. Madame Normandin, 6 minutes, s'il vous plaît.
Ms. Normandin, you have 6 minutes. Thank you. Thank you to all the witnesses for being with us today. I would like to start with Ms. Gaumont regarding a comment made by Mr. Chipper regarding safety of private data, and you earlier mentioned Cambridge Analytica. We also talked about the data leak in Alberta, so if you could come back to that, that would be great. The Cambridge Analytica scandal, I think, was a turning point for Canadians and Quebecers regarding their privacy online. It led to privacy reforms, and so I don't see how one could claim that it is not an issue. You made a recommendation regarding 444.6.1 and others that the government is exonerating itself from the application of certain provincial legislations. And if parties were subject to provincial legislation, there might be some disparity depending on the province. Could you share the advantages, the disadvantages, if the parties were subject to provincial legislation? I think that the goal would be to have a pan-Canadian approach and would be similar to what applies to the private sector. And so I think that allowing Canadians the right to exercise their rights wherever they are is important. Could a party then have an internal policy that would be based on the province with the strictest legislation to ensure that they could comply throughout Canada? Could that be a good way to ensure that we are responding to the legislation by following stricter guidelines? We've heard about the Brussels effect, where the rest of the world adopted similar standards. Platforms wanted to adapt similar policies, so they all complied with the highest standards. We could envision something similar here. A BC effect or a Quebec effect, yes. Can you talk about the provinces who have internal policies that we could look to? You talked about the role that you've played in Quebec. Could you perhaps give us a picture of what's happening at the different in the different provinces? Quebec and BC are currently the leaders. They have the most updated privacy laws. I think that we're currently at this state where we need to update our legislation, and political parties need to follow the same rules as all Canadian organizations. So if we simply respected the 10 fair information principles, so regarding consent and those other elements, so following that with some amendments for political platforms, I think that would be just the start. Thank you. Can you talk about the impact of not having policies for political parties? We want there to be more transparent, but is there a risk of disparity between the different political parties and the ways that they protect people's data? Is this a risk by not having a pan-Canadian strategy and not having an obligation to follow provincial legislation? Yes, there is a race to the bottom in a way that can happen. If other parties have practices that are less optimal, less responsible regarding protecting personal data, but gives them a political advantage, well, this might lead others to lower their values in order to have similar outcomes. This could potentially lead to a race to the bottom. I have about a minute left. If we were to impose higher criteria to parties, so as was done in Quebec and in BC, would this not give political parties additional support in, for example, the implementation of internal policies, in their management of IT systems? Could parties then request support in order to update their systems? That's a good question. If you're talking about financial support, I'm not sure. Technical support, actually. Probably. And this could also build more trust. Perhaps Canadians would be more comfortable sharing their personal information if they know that they're going to be properly protected, used appropriately, and if they know what they have consented to. So having responsible policies is good. This could be beneficial for everyone.
Close. This was going to be the first time that we were all under six minutes in the opening round, but Christine is usually our best student and is usually always under 6 minutes, but I'll strive to do better in the second round. Mr. Calkins for 5 minutes, please.
Thank you. Mr. Chapur, in your opening remarks, you were listing the 4 items that you wanted to address. I think you had to stop your remarks after about the third one. I think the fourth one dealt with protecting freedom of expression. Did you want some more time to adequately address that?
I don't, because I was able to slip it in my response to
okay,
your colleague, Ms. Briere.
All right, good. I just wanted to make sure. In your opening remarks, when you talked about the voters list, you suggested that the cure is worse than the disease. Would you elaborate on that, please?
Well, all of those rules related to privacy are going to apply to all of you. You're putting handcuffs on yourself. That's number one, to keep in mind. Number two, freedom of expression in our Constitution has always been about political expression that is unlimited, and your ability to express yourself to all of your constituents could be severely hampered if we applied normal privacy considerations, because under normal privacy considerations, you can be blocked. They can say, you can't talk to me, you can't send me an email, you can't call me. To me, that is pretty close to a violation of not just the Charter, but the whole idea of parliamentary government. The idea of our system is everybody communicates on political matters, and no one is able to say, I'm not playing, I'm not going to participate. So I just don't think that privacy laws should apply in the political realm. But if they are going to, certainly they have to apply the same at the federal level. We can't have the provinces involved. That would be a disaster if you allowed the provincial laws to apply. So it has to be federal. But I recommend none. There's no need. And think about it. Thousands and thousands of people go door to door knocking on doors and asking people to vote for their favorite candidate using those lists. I think that this concern in Alberta is way overblown. There is no problem with people communicating with other people and people knowing names and addresses because it's out there. You can get it from so many different sources. The information that is important to be protected is how you vote in the ballot box. And the Chief Electoral Officer does a very good job of protecting that information. Beyond that, I don't think there's anything that needs to be protected.
Okay, thank you very much. Moving on to your third item, you talked about a different proposal for the ballot, and I wasn't sure I quite understood what you were talking about. Are you talking about a 2-option ballot where you can either vote for the party or you can vote for the individual? Could you explain to me why you would change and put the party names first? I want some clarity on that.
Well, number one, because parties have been regulated, and parties are what makes our parliamentary system work. Parties are heavily regulated and provided for in the legislation. So my idea is that you take the parties, you list them, maybe in alphabetical order, it doesn't matter, and then an individual can choose a party. It'll have the name of the candidate and the party, and then that just rotates through each ballot, gets a different one at the top, and it rotates, but it's the first thing you see on the ballot. You can ignore that and say, I don't want to vote for any of the parties. I hate political parties. I'm going down to the list of independents. And then the independents would then be listed separately, rotating, but they would not, in effect, hide the political parties. You would put the political parties first on the ballot, and then all of the individual candidates would follow. But you only get one vote. You either vote for a party with a candidate name, or you go down and list go down the list to those who are not associated with the political party who've decided to run anyway.
Are there any changes that are being proposed in the current legislation where the the intended consequences are obvious? My concern is the unintended consequences being more problematic. Is there anything that you would recommend to this committee or recommend a change for, other than the ones that you've already listed, that this committee consider?
No, I think I've given you all of the biggest one, though, and this is something that the two decisions from the court have highlighted over and over again. My recommendation, pull the chief electoral officer and commissioner out of any discretionary role. Their neutrality is protected by them carefully following a statutory provision. They need to be restricted to making those kinds of decisions, applying the statute as written. They should not have a discretion with respect to party policy on the issue of privacy. I mean, it just doesn't make any sense.
Thank you so much. We'll now turn to Madame Kaibaga for 5 minutes, please.
Thank you, Chair. I'd like to also welcome our guest today, and we welcome Mr. Lowen as well. Mr. Chipper, just back to you a little bit. Regarding your concerns about criminal penalties for conveying false information, the threshold in the bill is intended to prevent capturing personal opinions or parody and to moderate any potential charter concerns. With that in mind, can you comment on the threshold contained in Bill C-25 that requires a person to know the statement is false and to make it with the goal of undermining trust?
The problem I have with the 482.01 is not that we shouldn't have some rules. My concern is just one area, and that is Part 20 gives the right to challenge the results that have been stated. And in my view, by giving the commissioner the option to charge, it creates in my view, a high standard for the individual to try to prove, particularly if it turns out what they said was not true. They may have someone who reported to them. They shouldn't have relied on that report. They went forward. It's just the problem of having to defend oneself for no good reason. There's no good reason to stop someone from commenting on the results of an election. It just won't impact the election. So let's not create an administrative burden for no purpose.
I think many people who have commented on this specific issue would have a divergent view on that, because the goal is to keep Canadian trust and make sure that there's no false statements being made about candidates and no interference on that. But I do want to go to another question. Just because of time, I really do want to get to my next question. With respect to the concern that you have raised around third parties using their own funds. There are still reporting requirements for third parties with respect to the source of the funds. Reducing the 10% threshold would prevent third parties from using their own funds to pay for regulated fundraising activities, even if the funds are generated entirely in Canada and from Canadians. This would also prevent them from engaging in regulated fundraising activities and consequently from exercising their charter rights to freedom of expression under subsection 2B, freedom of association under subsection 2D, and the right to vote, section 3. As I'm sure you are aware that Canadian courts have a history of scrutinizing restrictions on third-party participation in elections, as illustrated in, for example, Harper versus Canada, Attorney General 2004 regarding spending limits, and Ontario Attorney General versus Working Families Coalition Canada, Inc., and 2025 regarding limits to political advertising outside of election period. Although the Bill C-25 takes many important steps to close channel for dark and foreign funding, it also strikes at an important balance to ensure that Canadians' charter rights are respected. So I'm hoping that you can speak on the importance of protecting our Canadian charter rights.
Absolutely, and one of those rights is equality, and certainly by using 10%, That's just not equal. So if you wanted to use $1,000, $10,000, $100,000, and say that's the limit that can be given by a third-party organization that is not using some bank account where individuals deposit money, I'm all for that, because then it would apply to everyone equally. But 10%, when you have such a diversity of third parties, certainly is not equal. And so my view is that's a limitation on freedom of expression that simply is not justified in a free and democratic society.
Do I still have time, Chair?
40 seconds.
40 seconds. Peut-être si je peux entendre à vous, Madame Eve.
Ms. Gaumont, you talked about the ways that we could improve digital participation. If you have any suggestions in about 20 seconds. There needs to be a registry of political ads, needs to include more information, including an Elections Canada registration number and information on the ads that were used. Thank you.
Madame Normandin, 2.5 minutes.
Ms. Normandin, 3.5 minutes. Mr. Lowen, you talked about the importance of names and how they reflect the geographic realities of ridings, and you talked about historical names that and historical names. And if you could talk about how a historical name can be linked to geography. If someone founded a city, for example, or a town, should we consider the importance of that historical nature that had an impact on the geography of certain ridings?
A mix. Look, I think there's a whole series of processes that places are going through right now to change names, to remove people's names from things. For example, my old hometown of Toronto is going through this with Dundas Street and other things. I think it's an interesting exercise. I think the point more generally is that when we add names to things rather than taking them away, we add to our history. And I think we've spent a lot of time in the last number of years thinking that we could cleanse ourselves of things that have gone wrong in the past by removing names rather than just coming to terms with what happened when it happened. And I think for the commissioners in this case, the belief was that by representing the important historical and contemporary Indigenous communities that are involved with some ridings and that have the right of being represented in Parliament, that was a positive way of recognizing Canada's Indigenous history and Indigenous present, rather than, the more I think less helpful exercise of simply removing people from things, thinking that it will somehow change the past when it doesn't change the past or the future.
Merci. Et rapidement, Maître Gaumont.
And briefly, Ms. Gaumont, on online activities by political parties and transparency, can you talk about what's being done thanks to the Elections Act? Is there true transparency, or is that also part of the shortcomings in the bill? It's not included in C-25, so it could be considered a shortcoming. There was a registry, there was a bill in 2016. I think that we need to work with social sciences researchers to really understand the needs and then legislate and codify. Thank you very much.
To be cruel, given the time, I'm going to do 4 minutes to each for each member because we have to suspend. So I apologize for my cruelness, Mr. Jackson, and please proceed.
You're 2 weeks apart, Mr. Chair. I thought you'd be in a better mood. Oh, dear. Anyway, thank you to the witnesses for being here. I sincerely appreciate your testimony today. Mr. Jipper, just to pick up on your second point that you mentioned in your opening statement about the lack of judicial review for the commissioner in certain of their new powers coming forward in this piece. I just wondered if you'd elaborate a little bit more on what some of the unintended consequences of that may be for individuals in Canada should this come into effect as it currently sits in the bill.
The problem is the decision in Longley, which is an Ontario Court of Appeal decision, said that care should be taken to ensure the impartiality of this critical public role. That's the role of the chief electoral officer and the commissioner, we can add. So if we have an individual that is intended to be neutral, becomes the prosecutor, then we have a situation where there will be a perception that the party is not neutral. So the way to bring back a perception of neutrality, because the commissioner does at times have to prosecute, is to put judicial review of that decision so that there can be better or more confidence in the decision, a very powerful decision, because if it was done in the criminal area, it would be absolutely unconstitutional. But because it's administrative law, the Supreme Court has allowed this kind of law to be in place. In my view, it should not be in place in election laws because of the important neutral position the commissioner and CEO must play. And the Court of Appeal has effectively said that's mandated. And so my recommendation is that this committee recommend that the rule in 510.03, 510.01 apply everywhere. Always require a judicial oversight. You have to ask the judge with an affidavit where the commissioner says, I have evidence that leads me to want to ask questions of this individual. I want to have permission to do that.
You don't see there being any challenge of that being overly burdensome of a requirement to have in place?
No. It's what happens every day when the police deal with everything from drunk driving to a theft and possession of stolen goods. So it is a normal part of everyday policing.
Okay, very good. On the piece, we discussed briefly about questioning an election result. Do you have any examples of somewhere where someone has knowingly questioned an election result? Or I'm just trying to get around are we creating a solution for a problem that doesn't really exist here?
I'm not aware of any, and more importantly, I mean, there have been, over the last 40 years, I've heard of cases where someone took a ballot box home. And what if there was an allegation and then it turns out it wasn't true? Then did they act in good faith? Did they have enough information to make the allegation? And to me, why would you do that when, in fact, it can't have any impact on the election because the election's already done?
Well,
so I'm just saying take it out because the election's done.
And in fact, the chief electoral officer confirmed that it's actually normal process for ballot boxes to be taken home in some circumstances by deputy returning officers for storage until they can be opened and counted. Yeah. So, I mean, if someone is
when they come back with more ballots than were issued, it sometimes raises questions.
Yes, exactly right. No, I thank you for that testimony. How am I doing for time?
9 seconds.
Okay, well, thank you very much.
Thank you. I will be equal in my cruelty. Ms. Fancy, 4 minutes, please.
As always, thank you very much through you, Mr. Chair, and thank you to the witnesses today. I'd like to talk primarily with Mr. Lewin today in regards to nominations, unique official agents, and long ballots. So with our bill, with C-25, it contains kind of two primary measures to deter these unruly long ballots. Notably, voters can only sign one nomination paper, and that each candidate in a riding will also need one official agent. I'm wondering today if you could speak to the importance of including both of the measures that we have proposed in Bill C-25. And what you think some of the merits of each of these measures are individually, and also what you think is important or why it would be important to include both. Thank you.
Thank you very much. I had last autumn, I believe, on this long ballot measure, and I was glad to be included in that. The long ballot effort is an effort not to enhance Canadian democracy. It's just an effort to gum up the works by people who have tried to reform the electoral system and have lost at every occasion that they've done that. That's just the political reality of it. I'm glad you're trying to address it because I think it's a nuisance and it's burdensome to elections. On those two particular measures, limiting a single agent for single candidates, I think, is a very advisable thing. People may have a hard time convincing 200 other people to get involved in their shenanigans in trying to create long ballots. On the issue of an individual signing multiple candidacies, I think there's a potential for it being a problem only because we all know people in our communities who are local notables who help anyone out, and you can imagine them being approached 1 month to sign a person's nomination. They sign it for the person to be on the ballot, and then they sign another one a few weeks later, and they forget that they've done it. So the potential for that to be not restrictive in creating candidates, but just to create problems after an election that further government the works, I would be concerned about that. But to the degree that the parties here can just recognize that these long ballots are not helpful to helping voters find sincere candidates on their ballots, I think it's highly advisable that you do something.
What about the last part of the question regarding having having some of these official agents doing with multiple candidates?
Yeah, so to be certain, I think having allowing people to only act as an agent to a single candidate per riding is reasonable. I think that the restriction of if you try to have a single agent, if you say that an agent can't work for multiple candidates across ridings, it becomes restrictive especially for startup parties.
Thank you. And I come from a rural coastal community where sometimes there's only 1 or 2 people that have that type of notability around the area, so I can see that piece. My second question is, can you share your thoughts regarding some of the provisions with Bill C-25 that seek to prevent anonymous and sometimes hard to trace contributions by prohibiting political entities for all of their activities and third parties for regulated political or election activities from accepting contributions in the form of either cryptocurrency, money orders, prepaid payment products. So I'm wanting to know what you think that if this measure will help ensure transparency in our political financing regime.
I'll just make 2 points on it. One is that I think that trying to regulate the medium of exchange will become increasingly difficult. The crypto stuff is all a gray area, but there are methods of payment which are becoming more acceptable and regularized. The bigger challenge for you as a committee and with bills like this is the following. Whatever one thinks about restrictions on third parties, to Mr. Chipper's point, it is the law. We've established that we're allowed to limit the speech of third parties so that elections are mainly fought between political parties. The way that's normally done, and you see it in this bill, is by regulating what individuals or organizations do, saying these ones can speak and these ones can't. And the second is that is, say, legal entities or persons in a sense. And the second is to limit spending with the notion that spending is what equals speech. It's very plausible that we're getting into a world in which it's not people you're trying to regulate, but agents, that someone is setting up a series of agents online which are then distributing information. They're not people and they're not organizations. They're something else. That's one. And second, they do it at a cost basis close to zero. So the idea that you will regulate speech of people who shouldn't be allowed to speak during elections by identifying individuals or organizations and by limiting their spending as a means for doing it is, pretty soon that we'll be fighting last year's war. And that becomes a real challenge for you from a regulatory perspective.
Thank you so much. I'd like to thank our witnesses for appearing today. The committee will suspend for a few minutes while we set up our next panel. Thank you so much. As an individual, Holly-Ann Garnett, class of 1965, professor in leadership, the Royal Military College of Canada by video conference. Chris Tenov, assistant director, Center for the Study of Democratic Institutions, the University of British Columbia. And in person, the co-founder of Democracy Watch, Duff Conacher. You'll each have 5 minutes, and since you're here, Mr. Conacher, we'll go to you first for 5 minutes.
Thank you very much, Chair, for this opportunity to speak before the committee on this very important Bill C-25, Changing Canada's Election Act. This is the 8th or 9th time that I've been before the committee concerning this law. I will make my presentation in English. Il faut que je pratique mon français beaucoup, et il y a beaucoup de
I have been practicing my French, but there's a lot of technical terms in the matter at hand.
Of the recommended changes to the bill that I'm summarizing today. Changes to close the huge loopholes in Canada's election law that allow for secret, dishonest, unethical, and undemocratic interference and influence by foreign governments, businesses and organizations, and by wealthy interest groups and individuals in Canada's nomination and party leadership contests and elections and by-elections. I also filed a detailed report on changes needed to close these loopholes with this committee in February during its study of foreign election interference. And if you want even more details, you can find my PhD thesis online, but I warn you, it's more than 900 pages, so that's a lot of detail to absorb. Unfortunately, the provisions in Bill C-25 in its current form are incomplete, weak, and ineffective, and will do much too little to close these huge loopholes. Flaws and gaps in the bill mean that, among other failures, it fails to fix election dates. Snap elections are fundamentally unfair in many ways, including that pre-election spending limits do not apply when a snap election is called. The bill also still allows most disinformation posts on social media because the prohibition in the bill is much too narrow and unenforceable. It only applies to some false claims that a person knowingly posts with an intent to affect the outcome of the election or by-election. And the Chief Electoral Officer and Commissioner of Canada Elections testified before this committee and in the Senate in 2018 with regard to Bill C-76, and both said that proving intent is essentially impossible, and so if you require it, it makes the measure unenforceable. The bill also still allows donations that only wealthy voters can afford. The total annual donation limit currently is a combined $3,550, which is much more than most voters can afford. 75% of donors only give $75 each year. The bill increases secrecy of fundraising events by lobbyists and people who want something from party leaders, making it essentially impossible to determine if a lobbyist is helping organize or holding a fundraising event for a party, riding association, or candidate or nomination contestant or party leadership contestant. And it does nothing to require disclosure of other fundraising activities, and all that secrecy is a recipe for corruption, waste, trading of favors, and other abuses. The bill fails to require disclosure of donations to and spending by third-party interest groups during nomination and party leadership contests, unlike in the U.S., which does require disclosure. It also continues to allow third parties to use their own funds to influence elections, which hides the actual donors of the money, because the measures in Bill C-25 are easy to get around. And that's also unlike the U.S., which requires disclosure during primaries and election years of all donations to third parties known as political action committees in the U.S. The bill, so just to be clear, our measures in Canada are weaker than the U.S. measures during an election year for third parties spending and disclosure and donations. The bill fails to set lower spending limits for third-party spending by individual voters and businesses and organizations, which are only supported by a few voters. The only effective way to close these loopholes, to ensure free, fair, and democratic nomination and party leadership contests and elections and by-elections, is to prevent, prohibit, and penalize disinformation and secret and unethical and undemocratic influence. And Bill C-25 does almost nothing to prevent these activities and much too little to clearly prohibit them. It is good that the bill is increasing the penalties significantly in all of these areas. If you are in favor of and support and approve of Bill C-25 in its current loophole-filled form, then you support and approve of unfair snap elections called at a time that favors the ruling party, foreign government and foreign entity-funded front groups continuing to interfere in Canada's political system by secretly spending unlimited amounts of money to influence nomination and party leadership contests, foreign government and foreign entity-funded individuals continuing to interfere in Canada's political system by spending millions to influence a federal election. Only one voter or a number of companies supported by a very few voters are still be allowed, if this bill passes, to spend millions of dollars of their own money directly or through funneling donations to interest groups, most of it secretly with no disclosure of the individual's entity or the people behind the numbered company.
Thank you, Mr. Conacher. We'll now go to Ms. Garnett, who's online for 5 minutes, please.
Thank you. Thanks for this opportunity to speak to this committee today. I'm the class of 1965 professor in leadership at the Royal Military College of Canada and hold cross appointments at Queen's University and the University of East Anglia in the UK. I'm also the co-director of the Electoral Integrity Project, an international network of scholars and practitioners seeking to improve the quality of elections with academic evidence. My current Canadian research agenda focuses on political financing and public trust in elections. In this vein, I wanted to address in my opening remarks the issue of third-party financing regime that has come up in previous discussions of this committee. I hope to give some additional context from the broader study of electoral integrity. Third-party financing regimes in Canada seek to balance two democratic principles. On the one hand, the freedom for all groups and individuals to engage in deliberation, and on the other hand, a desire to see that, firstly, these conversations are not drowned out by a small number of well-funded groups or individuals, and more recently, that only Canadians are engaging in this debate rather than foreign actors. On one hand, there is reason to be wary of overly limiting third-party spending in elections. Third parties come together as Canadians to share beliefs or concerns about issues. The organization of citizens around common goals is important for a robust civil society and thus a robust democracy. Third parties have included advocacy organizations, medical or trade associations, unions, or corporations. These are all groups and people that we want to engage in the conversation during elections and that may have expertise or experience that can enrich the political debate. To put this debate in context, it is important to remember that third-party spending limits in Canada are among the lowest in comparable democracies. In the UK, limits were approximately £700,000, and there are no third-party spending limits currently in effect in Australia. To put this in perspective, third-party spending limits, if an election were held this year, are about $630,000 overall, or a little over $5,000 in a specific riding, compared to spending limits of over $35 million for a major political party. So we're talking about an already quite limited amount of money. From listening to the discussions about Bill C-25 that have already taken place, my understanding is that the main concern identified is less about the strength of third-party voices in the deliberative space of elections and more about whether the funds used to contribute to this debate are authentically Canadian. Bill C-25 makes really important steps in this regard. Firstly, the prohibition against donations of less easily traceable contributions, including anonymous contributions, can help provide transparency. And the addition that third parties must not simply be based in Canada to influence elections helps to close a potential means for foreign actors to game the system. Yet one concern that has been brought up in this committee is whether to allow third parties to use their own funds if the contributions they receive are not over 10% of their annual budget. This could open the door to allowing foreign entities to fund third-party campaigns via other revenue streams, such as general donations or payment for worker services. However, I believe this to be an entirely reasonable balance between the principles of freedom of debate and freedom from foreign interference that I mentioned earlier, for a few practical reasons. Firstly, not all third parties are contributions-based organizations. They may use membership dues or revenues of a corporation. Thus, the 10% rule seeks to ensure that these types of third parties are not pushed out of the electoral conversation and can engage in the debate with their own revenues. Secondly, third parties do not register until the pre-electoral or electoral period in the current regime. Since elections can take place at largely any point in Canada, third parties must be allowed some flexibility to use their own funds in engaging in the electoral debate. All this being said, I am enthusiastic about the steps towards further strengthening Canada's third-party financing regime. It is already one of the most stringent and well-respected around the world, and this bill will enhance the safeguards already in place. In the Q&A section, I would also be pleased to discuss other parts of the bill, including measures put in place to ensure the seriousness of candidates and their nominators, the the measures to include the nomination process in electoral safeguards, and means to address disinformation. But I'll leave it there for now. Thank you.
Thank you so much. We'll now turn to Mr. Tenove for 5 minutes, please.
Well, thank you very much to the committee for inviting me today to discuss how to protect Canada's elections. My name is Chris Tenove. I'm a political scientist and the assistant director of the Center for the Study of Democratic Institutions at the University of British Columbia, where I research digital media, democracy, and tech regulation. Today, I'm going to focus on challenges posed by artificial intelligence and social media. And my general observation is that Bill C-25 resembles a security patch for electoral software. It fixes some important weaknesses and should be promptly enacted, possibly some changes, but a more substantial update to the operating system is still needed. So I will flag gaps that remain regarding 4 issues: AI-generated content, false claims about electoral processes, chatbot errors and bias, and AI agents. First, generative AI can create synthetic media that impersonates individuals or official publications. That's a real risk, and the amendments to sections 480.1 and 481 are appropriate. The chief electoral officer and others have suggested that all synthetic content in electoral communications should be labeled as well. That may be helpful, but I don't think it's essential at this time. Enforcement would be difficult, and the core problem is misleading content, not necessarily that it is AI generated. However, the deceptive use of unlabeled synthetic content could be a factor when determining whether an actor is being intentionally misleading. Second, generative AI and social media platforms make it easier to spread false claims about electoral processes. C-25 appropriately clarifies and expands prohibitions on such claims. I am sympathetic to the Chief Electoral Officer's proposal to add intent to delegitimize elections as a prohibited purpose, though that language may need to be narrowed. Importantly, neither the Chief Electoral Officer nor the Commissioner of Canada Elections currently have the authority to require prompt removal of prohibited impersonation or false claims about elections processes. The BC Elections Act gives Elections BC exactly this power, and I propose that equivalent authority be given to the Commissioner of Elections Canada. Third, citizens increasingly get civic information from general use chatbots like ChatGPT, AI companions, and AI search tools. However, these models sometimes give incorrect information regarding elections. For instance, Demos, a UK-based think tank, tested several AI services during the Scottish parliamentary election and found 34% of responses contained factual errors, including wrong dates and hallucinated candidates. Such errors could harm election participation. Beyond errors, AI services may deliver biased outputs. For instance, in 2025, the Dutch Data Protection Authority warned voters not to use chatbots for voting advice after finding that popular chatbots vastly overrecommended certain parties. Risks of bias become more acute if AI models face data poisoning attacks or are designed to advance a bias, perhaps in alignment with business models. It's worth noting that OpenAI has begun running ads on ChatGPT in some markets. So election laws should ensure that chatbots and other AI services document and report all political ad spending, and C-25 should close any gaps. Moreover, just as the Election Act was amended to improve transparency for social media advertising through ad registries, we need new mechanisms to bring transparency to AI services to address harmfully inaccurate or manipulated information. And fourth, AI agents can do more than create content. They can plan, take autonomous action, coordinate across platforms, and raise and spend money. Responsible actors will build in human oversight, but malicious ones will not. So I suggest you confirm there is language holding responsible those who use AI agents for prohibited activities, and requiring parties and other actors to ensure there is a responsible individual or organization behind all contributions. Finally, election law alone cannot detect, stop, and secure accountability for malicious AI agent activity and other threats I've mentioned. It needs to be supported by broader AI and platform regulation in order to act on illegal activity and to impose obligations to mitigate systemic harms. We also need stronger protections for citizens' data held by political parties. These are all parts of the updated operating system that I think Canadian democracy needs, in addition to the near-term patch that C25 provides. Thank you, and I look forward to your questions.
Thank you so much. We will now go to questions. We'll turn first to Mr. Cooper for 6 minutes, please.
Thank you, Mr. Chair. I'm going to direct my questions to Mr. Conacher. You cited what you characterized as being huge loopholes in the bill, including with respect to the third-party financing regime, which would allow the use of foreign funds. I presume by a major loophole, what you were referring to as the exception in the bill, whereby certain third parties could use their own funds if contributions constitute 10% or less of a third party's revenue in the year prior to the pre-election period. Is that the loophole you're referencing?
Yes, and the key thing that others are not mentioning is it is just the threshold of 10% of your revenue during the previous year. And you can choose the fiscal year or calendar year. And so it makes it very simple for someone to make a donation before the previous year, a huge donation, and then you can use those funds as your own funds and not disclose where that money came from.
And
so it's a ridiculously huge loophole, and what it should be extended to is 0% is what the threshold should be, and it should go right back to the last election.
Yeah, and when you talk about it being quite easy, it's easy because in a fixed election date timeline, it's quite easy for third parties and foreign interests to make donations or solicit donations 2 years in advance, for example, and those funds would be treated as melded.
Even in a snap election mandate, just make the donation now. It's highly unlikely there will be a snap election for the next year. And this allows one voter could donate millions to several interest groups, knowing that they're going to spend it during the election in a way that that voter likes, and then spend themselves during a pre-election period up to the 2 months if it was a fixed election, right up to the election campaign period, millions of their own, and then spend $1.6 million. And the only disclosure would be of the $1.6 million spent, or if it's a snap election, only of $630,000 of the spending. All the rest of the spending would be by someone we don't know, and no disclosure of that. And again, the U.S. rules are much stronger in terms of disclosure during an election year.
The notion that 10% or less of a third party's revenue comes from contributions, that could be millions and millions of dollars of foreign funds.
Yes, it could be millions of dollars, and also government grants are not, and contributions are not counted. And so governments could fund groups that they support, that they know will support them, and that will not be counted amongst the 10%, so that even increases the loophole in terms of where the threshold is. So it's just a huge loophole that will facilitate foreign interference as well as unethical and undemocratic domestic interference.
So one way...
I'll pause your time, Mr. Cooper. I also speak with my hands, Mr. Conacher. Just watch when you are speaking with your hands not to hit the mic. So my apologies, Mr. Cooper. Please continue.
Okay. So one way to close the loophole on foreign funding is to require all registered third parties to set up a separate bank account for regulated activities with the requirement that contributions to such an account come exclusively from individual Canadians. Does that seem like a reasonable amendment to you?
Yes, very much so. That's what should be done.
And what about the argument that somehow this infringes on freedom of speech, freedom of expression, that there are charter implications? Do you have any thoughts on that?
No, disclosure requirements by the Supreme Court of Canada have been upheld as entirely constitutional. The only issue has been with the limits, and this is not about the limits. I think the limits also need to be changed. It's crazy that one voter is allowed to spend up to $1.6 million during a pre-election and election campaign period, which is the same amount that a citizen group with 100,000 supporters is allowed to spend. I mean, that's not democratic. It allows one wealthy Canadian to have as much influence as 100,000 Canadians. So that's something that also has to be done, and I think would be upheld as constitutional by the Supreme Court based on its most recent ruling in the case Working Families.
Okay. And on spending limits for third parties, you recommended lowering spending limits. We heard, in contrast to your position, Professor Garnett speak about spending limits for third parties in other jurisdictions. The UK, she cited £700,000, I believe, and in Australia there being no spending limits. So it's an open-ended question, but would you care to address that point?
Yes, right now you have one blanket spending limit. If it is a fixed election, then about $1 million during the pre-election period and just over $600,000 during the election campaign period. It's crazy to have one spending limit for many different types of third parties. Democracy Watch's position is actually that businesses should be prohibited from spending. They already have economic influence. The executives that make the decision on the spending are not representing either shareholders or workers. One voter should be limited to spending a very small amount. And then citizen groups, any type of interest group, should be allowed to spend a multiple of the amount that one voter could spend based on their actual number of voters that support them. Someone can have a numbered company supported by very few voters, or one voter can spend $1.6 million influencing the election. Same amount as a citizen group with 100,000 members. It's not democratic at all. It's not egalitarian. I think it violates the Supreme Court standard. It just hasn't been tested in court.
Thank you so much. We'll now go to Ms. Vandenbeld for 6 minutes, please.
Thank you very much, and thank you to all of our witnesses for your expertise. I'd like to start just by talking about something we heard earlier today, some questions around the clauses in the bill around spreading of false information. Obviously, in the bill, as you have mentioned, it does say that you have to know that the information is false and that the objective and goal of spreading the information needs to be to undermine the trust. So I know all three of you have previously testified and spoken and written about this. I'd like to start with Professor Tannov and then hear from the three of you about whether or not you think that this is a legitimate way to address it and it does not impact freedom of speech. So, Professor?
Yeah, I think that the bill as it's currently scoped does protect freedom of speech in that it requires both the proof of the intent to deceive, the fact that the existence of false claims, and the intent to undermine the conduct or affect the results of an election. And so I think, in truth, I mean, in narrow time periods during campaigns, that does pose difficulties to regulators who want to try and identify and maybe take action on false claims that are spreading around election processes. And so in the elections, BC's recent election, there were a few cases of false information about the election being spread. In the end, they didn't use their authority to require a cease transmission, but found other ways to have it addressed. So I think it is a significant burden, but an appropriate one to protect speech, freedom of expression.
And Dr. Conacher?
Yes. Thank you. What's strange about the bill is some false claims are prohibited, so why not all false claims? It does make sense to make it knowingly because then you're targeting only the poster of not the people who share it, who may not know that it's false. But the Commissioner of Canada Elections and the Chief Electoral Officer said in 2018, if you require proof of intent, that makes it unenforceable. So just say anything related to the election that you make a false claim about, and I would extend it right through between elections, anything you make about, statement you make about any policymaking process that is false, that you will be sanctioned, it will be removed from social media. It's very difficult, as Professor Tannov mentioned, during an election campaign period to react quickly enough and have it judged as false and removed, but it still needs to be there to discourage the rampant disinformation that we're seeing, and it can be done. The key part, which is not set out in the bill, is we need to make the enforcers of this entirely independent from all political parties, all politicians. It cannot be seen or even appear to be seen as anyone with connected to any party or government as the people deciding what is false and sanctioning and removing posts from social media. But it needs to be done, otherwise rampant disinformation that misleads voters will continue to undermine elections. And everyone should realize that elections are decided by a vote margin usually of only 5 to 10%. And so disinformation only has to fool 2.5 to 5% of voters to have an effect on the election. So a very small percentage of voters fooled and changing their votes because of disinformation can affect the result of an election, which is why this needs to be dealt with. If it's not dealt with in Bill C-25, we need another bill very soon before the next election.
Well, thank you. And Professor Garnett, what's your view on this?
Thank you. So bottom line up front, the current bill as it is written, I think strikes a really good balance. One thing that we want to be very concerned about, though, is that we're not stifling debate, or that we're not discouraging people from entering the debate for fear that they accidentally end up being prosecuted for that. The other challenge that I've found in some of my research on disinformation is that line between what is true and what is false is not always clear. And this issue that Mr. Conacher brings up about who is adjudicating that and who is adjudicating what is a true and false claim is very delicate, and I think can be very easily weaponized, and we do see it being weaponized in other countries. And so to that end, keeping it within the limits of false information about the specific electoral process, I think strikes the right balance between encouraging there to be accurate information available to voters, while at the same time ensuring that we're not stifling any of the sort of debate and open contestation that is required to have a free and fair election.
So, Professor Tannov, on this issue of whether or not you can determine intent, you mentioned in your statement about the way that you could look at generative AI and how it's used to actually determine what the intent is of the false information. What if you could elaborate on that?
Yes, I think, there are different ways to determine intent and different standards that could be used to judge whether there's sufficient evidence. One way is to look at past histories of posting material, or which might show that there's repeated and strategic efforts to promote falsehoods. And the way that you referred to that I was mentioning is if there is evidence that someone has deliberately mischaracterized synthetic or AI-generated content as real, that could also be interpreted as evidence that they are being deceptive about the message that they're putting forward.
I'm going to have to intervene there. I do apologize. I will now turn to Madame Normandin. 6 minutes, s'il vous plaît.
Merci beaucoup encore une fois à l'ensemble des...
Thank you again to all of the witnesses. I'll start with Mr. Tannov. At the end of your remarks, you talked about protecting civic data. Can you tell us more about the shortcomings that the bill has regarding protecting this data and any recommendations that you would like to share with us in order to improve the situation?
Yes. So there are others who've commented on data protection, and I would defer to some of them. I think the one thing I would add on the conversation that occurred in the previous session is my sense is that the concern is not just the list of the voter list per se, but all the data that parties accumulate about citizens and then link to that voters list. And so it's this complete set of data that people may legitimately worry these could be either used in ways that are manipulative or are exposed to being lost through cybersecurity incidents or inappropriate transmissions and sales and so forth. So I think the essence is to ensure that that the data, that citizens' data is being protected, as a statutory right, and that there's some oversight, and that it's not entirely up to the discretion of the parties.
Merci beaucoup. Peut-être une question pour vous, Monsieur Conacher.
A question for you now, Mr. Conacher. You talked about publishing funding activities, and that it's not all activities that are well covered. We don't often have information on all of these fundraising activities. Were you speaking to political parties and their activities that are not well publicized, or were you speaking to activities organized by third parties, if you could make that distinction?
Yes, thank you for the question. The bill introduces a loophole in the current fundraising event disclosure regime where the exact location of a fundraising event will not be required to be disclosed, but just the municipality. And this will make it essentially impossible to determine whether a lobbyist or someone who wants something from the government is the one organizing or holding the fundraising event. And it's a huge step backwards, and it's a recipe for corruption, waste of the public's money, trading of favors, and other abuses. Democracy Watch's position is that nomination contestants, party leadership contestants, parties, riding associations, and candidates should all be required to disclose their staff, their top volunteers and campaigners, their fundraisers, and that is in order to be able to track the conflicts of interest that are created by the political favors done by these people.
Merci. Un peu dans la même veine.
Thank you. Now, something that was removed from the legislation with C-25 is the obligation to inform beforehand that an activity is going to happen. We talked about not identifying where it's going to happen in order to protect people who are organizing these events. But do you believe that we should maintain this information, or this information regarding an event? Should we be informed regarding the date the event is supposed to be held, the guest list, so some information before the activity?
I think advance notice is helpful. I understand that there were some protests in front of some people's homes. That information can come out afterwards, but at least to know that the event is happening in advance is important. There's just another small change which I didn't address in my recommendations, but I find it incredible that actually also a provision has been put in place that if a contestant, riding association, party, or candidate does not follow these disclosure requirements after the fact, they're allowed to keep the donations raised at the fundraising event. Why you would allow them to do that after they violated the law is just another ridiculous step backwards by the Liberal government in proposing this. This secrecy and these steps are, again, a recipe for corruption.
En d'autres termes, une personne pourrait avoir fait...
So, someone could organize a fundraiser in order to pay for a fine that they could have been imposed for not following the Elections Act, and they could keep this money. Is that correct?
And the fine would be less likely than the amount raised, and there would be no disclosure of who was at the event and who organized it.
Et rapidement,
And quickly on fixed date elections, are you saying that we should ban these snap elections, or should we frame the funding for these kinds of elections, snap elections?
It's very difficult to cover the pre-election period in a snap election because no one knows exactly that it's coming. But to take the last election, people were fairly sure that probably an election would be called after the leadership race, wouldn't wait until the fixed election date. And you saw people spending both against the Conservative Party leader and the Liberal Party leader enormous amounts of money with no disclosure of who they are. Because, again, we don't cover this. So fixed election dates, I mean, they're more fair for everybody. All the parties, people who want to run, volunteers, can arrange their lives. We should fix election dates like the UK had them fixed, where the only time an early election would occur is if there was a resolution passed in the House saying that the House does not have confidence in the government.
Okay, I'll have to cut you off there. We will turn to Mr. Calkins for 5 minutes, please.
So I'll let you finish that thought, actually, Mr. Conacher, because my question to you was going to be, there's two circumstances, generally speaking, in Canada where you would have an election that doesn't follow. I mean, there's political ramifications. There's no constitutional requirement to follow the fixed election date, but there are political consequences for not following a fixed election date when you have a majority parliament. In a circumstance where you have a minority or a hung parliament, as it's traditionally called, either the prime minister can call an election or there can be a vote of non-confidence in the House. Those are two different things. I would suggest to you that a prime minister would have advanced knowledge in his own mind and therefore to the benefit of his political agency, whatever that happens to be, when it comes to knowing what spending could or should happen in an undisclosed pre-writ period, for example. Only the Prime Minister and close people would know that. Generally speaking, the public gets a sense when there is going to be a vote of non-confidence that could actually topple the government. But how would you manage the pre-writ spending in what seems to be three completely different scenarios?
Well, again, if you fix election dates and there has to be a resolution in the House that's passed by a majority saying the House does not have confidence in the government, as it was in the UK, and the UK also said that then that could be actually repealed, that resolution within a couple of weeks after that, if there was something negotiated between the parties to continue the Parliament. You would know that the resolution has been introduced. I mean, there would be at least some advance notice to everybody. And all the rules could kick in at that point in time. So at least you would cover that period.
How would you deal with the Prime Minister, though, making that? So I mean, that's a completely different thing, right? Are you suggesting that we remove the ability of a Prime Minister to use his or her discretion to call an election?
Yes. Yes, and New Brunswick actually did that. They had more specific language than the federal election law. Demarsuach challenged the snap election call by Premier Higgs in New Brunswick, and the New Brunswick Court of Appeal said he violated the law. So it is possible to do it under our system and to only allow an early election if there is a vote of non-confidence, and the vote of non-confidence, the Brits had it right. Only a specific resolution of non-confidence is the only thing that would cause an early election.
Now, after the 2015 election, I was the chair of the Ethics Committee for a while, and I was actually pursuing the government on cash for access. It was called the cash for access scandals back in 2016, 2017. Yes. The law was subsequently changed when it came to the disclosure of political fundraising events and so on. Do you foresee now that with these changes being relaxed, that we're going to find ourselves in cash for access types of scandals again?
Yes, I think so, because the disclosure is coming after the event and only the municipality, and that makes it very difficult to determine whether someone's holding a fundraising event in their own home, which is where was the site of the cash for access scandals. So it's a huge step backwards in transparency and ethics to do this.
Okay. Thanks. I'm now going to switch to Mr. Tenove. My question for you along the, I don't know how it would all work insofar as regulating AI-generated content, but wouldn't the more valuable aspect of dealing with AI be in ensuring there's disclosure so that people know when they're consuming AI-generated content rather than actually trying to regulate the content itself?
I think so. One challenge is that, and regulators have experienced this in other jurisdictions. It can be, we use AI to do so many things on a spectrum of lightly modifying to significantly changing to, completely fabricating material. So determining where something is on the spectrum is difficult. Quite often, it's synthetic content is clear that it's being fabricated, and so it's not problematic. And so I think, in addition, we do not currently have great and reliable detection systems in order to identify these things. So it could be very difficult for a regulator to be able to, figure out when someone is transgressing a requirement to reveal synthetic content. So for these reasons, I think, it could very well be that this is something that we want to further develop, the capacity to ensure that we can identify manipulated or fabricated content But I think that the way the content is being used and what it is aiming to achieve is more critical, whether that be making false claims about how to vote, whether that be harassing candidates during an election, and so forth. And so that's why I think the emphasis should be there.
I apologize. I am going to have to cut you off, and we will turn to Mr. Genereux for 5 minutes, please.
Thank you, Mr. Chair. And thank you, Holly Ann, Duff, and Chris for being with us today. I'm going to stick with you, Chris, if that's all right. Going back, you've previously said a statement that I'd like to get a little bit more information on from you, if possible. You indicated that, and I quote, "As a result of false accusation from Trump, Musk, or others with huge hostile followings can expose politicians and others to a blizzard of online threats and abuse, and that," I quote, "foreign interference can occur by promoting misinformation." Do you think that the provisions in C-25 that prohibit false information where it is shown that the person knew the statement to be false and was made with the goal of undermining trust in the election, and as it results, can help with these kinds of challenges?
So I think that C-25 is focusing pretty narrowly on content that may jeopardize Section 3 rights to participate in elections. But there are broader, categories of harmful content that certainly can affect how campaigning is done, whether it's fair, whether it's trusted, and so forth. And I think that it's likely that it's more likely to address some of those broader issues in broader platform regulation rather than through specific electoral law, or in the case of harassment and threats through criminal provisions. C-16, which was introduced and looks to address non-consensual intimate images, I think is part of the mix too. So I do think there's a range of kind of regulatory and statutory approaches needed to address these issues.
Great. I'm going to try to get to two more questions, but we'll see if we have time for them. I'm going back to your quote database again here for you. You've expressed in the past that, and I quote, "foreign interference can occur by providing money for electioneering, rather than a single bundled sum offered to John A. McDonald. Funds are more likely to come through online donations, possibly including cryptocurrency transfers that are difficult to monitor," end quote. Given that, can you share your thoughts regarding the provisions in C-25 that will seek to prevent the anonymous and hard-to-trace contributions by prohibiting political entities and third parties from accepting contributions in the form of cryptocurrency, money orders, and prepaid payment products? I guess in short, do you think that this measure will help ensure transparency on our political financing regime?
I think that C-25 is a real step forward on that issue by specifying those forms of contributions. And I'll admit I do not have the background in the kind of mechanics of being able to track those to know how effective they will be. I just want to highlight that I agree with what Professor Lowen mentioned in the last session, which is that we are entering an era where the attempt to regulate unfair kind of production and dissemination of speech, including by foreign actors, by focusing entirely on spending for that speech is really jeopardized in the information system we have, partly through, I talked about AI agents and their ability to push speech that may appear organic, and partly through some of the unclear regulation around influencers, which Ms. Goman mentioned also in the last session.
And finally, hopefully within the next minute, talk about some of the enforcement powers of the commissioner. In the past, you've expressed that it's challenging to enforce laws against people who live abroad, and that in addition to measures in the Canada Elections Act, there needs to be strong international framework in place as well. Bill C-25 contains several measures that strengthen the enforcement powers of the commissioner. These include enabling her to enter into formal arrangements with international counterparts and national security agencies. Can you comment on how this increased enforcement power can help with some of the concerns that you have previously expressed?
Very quick answer.
Sure. Yes. I mean, I think it's simply that one requires often assistance from other jurisdictions to address cross-jurisdictional issues. And I'd say, given these real challenges, sometimes it may be necessary to have other processes to address speech that threatens people's democratic participation, which is why I suggested enforcement like cease transmission orders that the Commissioner could adopt.
Thank you so much. Madame Normandin, 2 minutes et demie, s'il vous plaît.
Ms. Normandin, you have 2.5 minutes. Thank you very much. Maybe a more philosophical question for you, Mr. Tenove. You spoke about AI-generated content, bots. These technologies are evolving very quickly. We often feel like it's a game of cat and mouse when we listen to witnesses. Can you tell us about the importance of considering two things as elected officials, that we need to focus on coming back to the drawing board and reviewing the legislation given the quick evolution of technologies, and that we should also never forget that the weakest link is the human. So voters are very focused on how things are done. So perhaps this is more of a philosophical question for you.
Yeah, I think it is very difficult to keep on top of every new mechanism that technology enable for political communication. We are in a situation in Canada where we lack independent regulators and frameworks really for both platforms and artificial intelligence. And so I think that conversation about how we want to address these quickly evolving technologies really needs to, direct its energies towards those developments. Key to that will be forms of transparency that allow us as societies to understand what these services, often companies, what they're doing, what they are sharing with Canadians, including during election periods. And so I think the kind of transparency provisions envisaged in an Online Harms Act and in attempts at regulations for artificial intelligence are really critical, because the first step is going to be understanding what is happening and what is being produced by these technologies.
Merci.
Thank you.
I'm going to continue my cruelty, Mr. Jackson. We'll go 4 minutes for the next 2 rounds, then call it a meeting.
Thank you, Mr. Chair. Just Mr. Tenove or Dr. Tenove, to follow up on Mr. Generou's questioning, actually. So your suggestion to deal with foreign interference or activities online, content for platforms that are owned or located in foreign countries, is to have the Commissioner for Canada Elections make agreements with similar officials in those countries to try to address breaches. Did I understand that correctly?
I think there's a couple routes of action. One is the more prosecutorial approach, which is identifying infractions and imposing penalties, possibly by pushing it into a prosecution phase. The other thing, though, that I was mentioning was the ability to directly require online platforms to cease the transmission of content that appears to be intentionally spreading false claims about the electoral process. Does that clarify what you're asking?
Sort of. I guess I'm just trying to understand how that would work in a real world scenario with a platform like WeChat, for example.
Mm-hmm. Yeah, I mean, so as it currently stands, the approach is that there are kind of relationships between I believe it's the Commissioner of Elections Canada and the platforms to make requests once they identify infringing content, but there is no real authority in order to have those acted on. And so, I suppose that beyond being able to apply penalties when platforms do not take down require content that the commissioner has signaled is prohibited, that there might be other means necessary to stop transmission in Canada beyond fines. That's something that I'm happy to sort of think through and get back to you on.
Conacher, I just wonder, on the topic of the commissioner, previous witnesses have raised concerns about the lack of judicial review for a commissioner acting. The commissioner's office would be put in the role of really fulfilling two roles at the same time if there's no judicial review mechanism for a complaint. And I wonder if you have some comment regarding that.
The Supreme Court of Canada is going to rule soon on a Democracy Watch case that was heard in January concerning the right to judicial review and for these kind of administrative tribunals, commissioners, agencies, boards. And the Ethics Commissioner currently has a bar to judicial review on certain areas. And I think that case will actually establish, the ruling on that case will establish the standard. Generally, the courts have upheld the right to judicial review when Parliament has tried to bar it. And so I don't think any attempt to bar judicial review will be successful in the long run. It's better to just remove it.
Okay, that's where I was going to get to. So your recommendation then would be for that provision to be removed from this piece of legislation.
Yeah, it's the court's rule and the proper rule in our Constitution.
Thank you.
Thank you so much. Madame Brière, 4 minutes, s'il vous plaît.
Merci, Monsieur le Président. Et
Thank you, Chair. My question is for Professor Garnett. We've heard a lot of comments and opinions regarding the 10% rule, so regarding contributions and how they cannot be over 10% of the yearly revenue. Can you speak to that, please?
Thank you for asking that question. I think the balance that is trying to be given in this particular bill would be this between limiting speech and then legitimate organizations having a voice within the electoral system. And so the idea behind that 10% rule is to ensure that organizations that are not contributions based would still be able to participate. So you can envision a situation where an organization is not necessarily in the business of fundraising to, and would be essentially left out of that electoral conversation if they weren't able to use some of their own funds. And one concern that I have about this idea that's come up about, well, maybe there should just be a separate pool just for those particular actions is one thing we might want to be concerned about is whether it does turn into more of the PAC-based system that we see in the United States. My understanding of third parties is that is existing groups and organizations within Canada, groups of citizens who want to have a voice in the electoral conversation. And so moving towards a system where it's just another avenue for contributions, another avenue for spending, I think might be a dangerous route to go on.
Et rapidement, avec le peu de temps qui reste, j'aimerais...
And briefly, can you also speak to the measures in C25 regarding disinformation and deepfakes?
Yeah, so one thing that I can contribute to this conversation is that limiting or putting within an election bill that one cannot say false things about the election, for example, something that's relatively new. We've done some comparative work where we're looking at how election law is dealing with the issue of disinformation. And Canada is actually one of the few places where that has been written into election law. There are very few examples of that cross-nationally. I think the thing that I'm concerned about is, while I think it's a step definitely in the right direction, one thing that we've noticed in some of our cross-national research is that there's very little evidence whether that actually ends up having the intended effect at the end of the day, whether it's enough to actually improve the quality of our discourse. And that's going to be where broader things that are not necessarily going to be able to be easily legislated through an Elections Act are going to have to come into play. Things like civic education, civic literacy, these longer term investments essentially in the population and investments in political institutions even. And so that's one thing I just caution. While it's definitely a step in the right direction, I think we can't expect it to be the silver bullet to be able to deal with the issue of disinformation in elections.
Thank you.
30 seconds. Okay. Thank you so much. I'd like to thank all of our witnesses, and this meeting is adjourned.